Thank you. We're on the record in the matter of the people of the state of Michigan versus Kira Evans. File number 23-00141. Council appearance.
Brian Ring on behalf of the people, Preston Michigan Court Rule 8.120.
Your Honor, Eric Tomal for defendant Evans, who's present.
Okay, today's date and the time that was set for a preliminary examination. My understanding there's going to be a 21-day waiver.
Yes, stipulated request for an adjournment of the prelim, motion to withdraw has been filed, and I went over the 21-day waiver with Ms. Evans.
Okay, the court did receive a motion to withdraw Mr. Tamal yesterday. You indicated that you are having a issue communicating with your client.
That's the least of the problems, but that's part of it, yes.
Okay. What's the problem, ma'am?
He doesn't want to fight for my case. I feel like I have a previous case. He hasn't sat down to have a scheduled meeting with me. He keeps talking to me unethical, screaming at me, losing his cool. I'm communicating with him. He doesn't want to communicate that.
Okay. Okay, so you both agree that there is an irreparable breakdown in the communication?
Yes.
Okay. And so this was a court-appointed case, correct?
Conflict, yes.
Okay, conflict case. So that means we would need to have the public defender locate you a new attorney. You understand that? Okay. And so you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned on January 15th. That's why your examination, sorry, January 17th. That's why your examination was set for this time. And I'm going to grant the motion to withdraw based on the indication stated here in your motion, Mr. Tamal. I didn't get into all of the details on the record, but I did read the concerns yesterday, and I do understand that the police had to be called. Is that correct?
Yes, at my office, they have to remove from my office.
Okay, that's correct, ma'am. I need to hear it on the record.
Yes, sir.
Okay. I'll grant your motion to withdraw. We think that there is a breakdown that's irreparable at this point. Do we have a public defender here?
Mr. Ross.
Okay, we'll see if we can get, I don't know if she needs to do an intake or what. How does she move forward in order to get a new?
Your Honor, if she was assigned conflict counsel, that means she's already done it and taken and approved. We'll just have to alert the office so that they can start finding another conflict counsel.
Okay, sounds good. And so who does that? Who alerts the office of that? Does Mr. Tamal let them know that he's been withdrawn? Is that how that works?
Typically,
Okay,
although
sounds good.
since I'm here, I can let them know as well when I get back.
That would be wonderful, but I'm also going to put the onus on Mr. Tamal, let them know that the court is granting the motion to withdraw, so they need to find new conflict counsel. Okay,
If I could get a copy of the order today, I have a copy in hand.
very good. Scribble comes back, we'll get you a copy of the order. Due to the motion to withdraw from council, I'm going to find good cause to go beyond the 21-day timeline. Ms. Evans, I'm going to reset your matter, okay?
Thank you. Do a PCC March 3rd at 1.
Probable cause conference would be March 3rd at 1 p.m.
Any exam, March 9th at 10 a.m.
Your new exam will be March 9th at 10 a.m. We'll get you a copy of the notice to appear. Do you have any questions today, ma'am? Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Okay, you can have a seat. We'll get you a copy of your notice, okay? Okay, who's next? Nope.
You're good.
Okay. Well, we'll move on. Mr. Silverthorne, did I see you? I did. We're on the record in the matter of the people of the state of Michigan versus Eric Odell, file number 22-03042. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Good morning, Dwayne Silverburn from the Office of Public Defender on behalf of Eric Odell, who I see is appearing on screen by Zoom.
Okay, Mr. Odell, can you hear us? Can't hear you though.
Yes, ma'am.
Okay, today's the date and the time set for preliminary examination. I have a note here that there is a request to adjourn. Is that correct?
That's correct, Your Honor. The people will be asking for an adjournment one more time, Your Honor. There are medical records that we're waiting to get a hold of. The medical release has been signed, and the detective is just waiting on the return from Sparrow.
Mr. Silverthorne.
This is correct. The request is coming from the prosecutor. However, the defense does consent to it. And I spoke to Mr. Odell yesterday, and he also consents to it.
Okay, sounds good. It looks like you've already adjourned the timeline, so that's not an issue. And the motion to further adjourn the exam will be new date. Mr. Odell, do you have any questions?
No, I do not.
Your Honor, if I might, I wanted to look forward to my upcoming schedule. A week from today, I will be picking a homicide case before Judge Alcolina, expected to last a week to 2 weeks. And then immediately upon that case finishing, I'm picking another capital offense case also with Judge Alcolina. And I estimate that my first available Friday date is Friday, March the 10th.
March 10th at 9:30. March 10th at 9:30.
Thank you, Your Honor.
No problem. Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of the defendant. Thank you, Your Honor.
Thank you.
Joel, you are free to leave, Mr. Joel.
Thank you.
Okay, and we're running that done. That's correct.
Maybe, Your Honor, I need one more moment to speak with Mr. Austin on that.
Okay, well, hold on, 7:30, let's see. Is Standish here today? Okay, so attorney here?
Mr. Coltrider might be down trying to talk to Mr. Eskins.
Okay, sounds good. Mr. White is here for Montreal Christian.
Right.
Yes, sir.
We're on the record in the matter of the people of the state of Michigan versus Montreal Christian, file number 22-02039 FY. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. Toby White. I'm here on behalf of Montreal Christian. He's in the jury box and I'm standing right next to him.
Today's the date and the time set for a preliminary examination. How are you, Mr. Christian? I'm sorry? Okay. Council, how are we proceeding?
Your Honor, at this time, I'd be seeking an adjournment in this matter as well. There is one video outstanding that we do not currently have a copy of, and defense needs a copy of it as well.
Mr. White.
Thank you, Your Honor. That's a complete statement and we concur.
Okay. Mr. Christian, looks like you were arraigned back on January 17th. You have the right to have a preliminary examination within 21 days of that arraignment date, but due to the pending discovery, the court's going to find good cause to waive the timeline so we can reset this beyond the 21 days, okay? Okay, Okay. Do you have any questions, sir?
March 9th and 9:30.
March 9th at 9:30 work for you?
Does, Your Honor.
We'll set it for that date and time. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor. Nothing further. Thank you, Your Honor.
Actually, I forgot that, I think we received a number of letters. I think, I'm not sure what they are. They were addressed to the court about the defendant. One is from a Deanna Ganelli. One's from a Messiah Bates, I believe that's what the name is. And Robin Carter. Did the prosecution and defense get a copy of these letters?
I would like, I have not seen those.
Okay, we'll get you a copy of it. Thank you. That's all.
Thank you, Your Honor.
Don't know where Mr. Noakes is. Mr. Austin is here, we just need his client, or he's to. See, okay, Mr. Austin, Mr. Mays here?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Donald Lee Mays, file number 23-00157 FY, counsel appearance.
Brian, on behalf of Field Practicing in Michigan Court Rule 8.120.
Morning, Your Honor. Jared Austin, appearing on behalf of Mr. Mays. He stands present to my right.
Thank you. Today's the date and time set for preliminary examination. How are you, Mr. Mays? I'm doing well, thank you. My understanding is that the parties are seeking to waive preliminary examination, is that correct?
That is my understanding, yes, Your Honor.
That's correct, Your Honor.
Sorry? I'll sign it. Okay. Then we can get it across the board. Okay. Is there an offer exceeded on this?
There was an offer, Your Honor. The offer was to the one count of concealed carry weapons, and people dismissed the remaining 3 counts, Your Honor.
Mr. Mays, you understand that you have the right to have a preliminary examination here in the district court?
Yes.
Okay. You understand in this matter that you are being charged with 1 count of weapons, firearms, possession by felon, count 2, weapons carried concealed, count 3, weapons carried concealed, count 4, weapons felony firearm as habitual offender second offense notice. You understand that, sir? You understand that at the time of the preliminary examination, you have the right to have the prosecution put forth evidence to establish that they have sufficient probable cause that crimes or these crimes were committed and that you committed these crimes. You understand that? You wish to unconditionally waive that examination in these files today?
Yes.
Anybody threaten you to get you to waive your exam? Any promises being made to you in exchange for waiving the exam? You understand that the waiver is unconditional, meaning that you won't be able to come back and have your exam once you waive it. You understand that?
Yes.
And you're waiving your examination in district court freely and voluntarily?
Yes.
Okay, I'll bind the matter over to the circuit court. Your bind over date's gonna be February 15th, 2023. You do not need to appear in court in circuit court on February 15th. That's the date they get the file from this court, okay? Your next court date will be a pre-trial in circuit court. You and your attorney will be made aware of that date and time, okay? Can you verify your address for me?
Home address,
Yes.
915 Cross Street,
Oh, and your phone number?
area code 541-224-271.
A bond was set in this matter at 3,000 personal recognizance. There's a curfew of 10 p.m. to 6 a.m. unless at work. That will continue. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing further on behalf of Mr. Mayor, Your Honor, thank you.
You're all set. Are you waiting for the matter, sir? Which matter are you waiting for?
Oh, I'm waiting for the copies and letters. I'm all done with it.
Oh,
The
okay.
bench.
You took it. Okay, thank you. on the record in the matter, the people of the state of Michigan versus Keith Eskin Jr., file number 23-00140. On fly, council appearance.
Brian Ring on behalf of people practicing under Michigan Code Rule 8.120.
Thank you, Honor. Dale Culture. On behalf of Jessica, proceeding needs.
Okay, today's the date and time that was set for preliminary examination. Are we ready to proceed?
We already got it. You're right.
Preliminary matters.
None from people, Your Honor. Thank you.
Nothing, Honor, just any witnesses.
How many witnesses do you have?
I have two here today, Your Honor.
Police or what?
Police, police, Your Honor, yes.
Okay. The sequestration order is granted. Any additional matters?
None from people.
Call your first witness.
People called Officer Ubera. He's present. Sorry.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
I do.
Thank you. You can have a seat. Proceed, Counsel.
Thank you. Can you please state and spell your full name for the record?
Officer Bailey Uberoth, P-A-I-L-E-Y, Uberoth, U-E-R-R-O-T-H.
Thank you. Officer Ubera, where do you work?
Lansing Police Department,
And how long have you worked there?
4 years.
In what capacity?
Road patrol, currently I'm assigned to community service.
And were you working for the Lansing Police Department on January 14th of this year?
I was
And were you working as road patrol?
in a road patrol capacity as a community police officer, yes.
And were you dispatched to Sparrow Hospital on that day?
I was.
Do you know the address of that Sparrow Hospital?
1215 East Michigan.
Is that in the city of Lansing,
Yes,
County of Bingham, State of Michigan?
yes.
Why were you dispatched there?
I was dispatched to a gunshot victim that was coming to Sparrow that had notified dispatch.
And did you have a description of a vehicle that they were arriving in?
I did.
What was that description?
It was a silver Kia SUV.
And were you the first on scene?
I was.
What did you see when you arrived?
I attempted to locate the vehicle. I didn't see one. However, a white Chevy Equinox pulled into the Sparrow ER parking garage, and I observed the driver and a front seat passenger exit the vehicle to assist with the rear driver's side passenger to help get out of the vehicle. I had an apparent gunshot victim.
Were you in uniform on this day?
I was.
And so you saw them get out of the vehicle?
I did.
Did they go into Sparrow?
Yes.
Did you follow them?
No.
What did you do?
I stayed with the vehicle for evidentiary purposes.
And was there anybody else left in that vehicle once these people got out?
Yes.
How many people were left in the vehicle?
One.
How do you know they were somebody in the vehicle?
I saw them through the window.
Did you identify yourself to them?
I did.
Did you try to get them out of the vehicle?
Yes.
So what happened when you attempted to get them out of the vehicle?
The subject was in the rear passenger side of the vehicle. I attempted to open the door and order them out. The door was locked. And he informed me that he was 13 years old and that his mom told him he could not leave. I told him that it didn't matter. He still needed to come out of the vehicle. At that time, he then reached up to the driver's side at the driver's seat, causing the horn to go off. I then transitioned from that rear passenger side to the front driver's side and attempted to open the door. At that time, he then went back to that original position,
The original position being
the rear passenger seat.
your passenger seat. Okay.
I opened the door, unlocked the door, and told him that he needed to exit the vehicle.
So So when you did this, you were in the front driver's side, right?
Yes,
And then he was back at the back passenger side.
yes,
Okay. Sorry about that. And so you unlocked the door
I did.
and told him he needed to come out.
Yes,
Did he come out?
yes.
What happened?
At that time, I told him he was not free to go. And then he began to flee on foot southbound towards Michigan Ave.
And you saw him run?
I did.
And how was he running?
He was running with his left hand pinned to his waistband, actively fleeing from me as I gave chase after him.
And you gave chase?
I did by identifying myself as the Lansing police, yelling, "Stop." Lansing police, stop is what I yelled.
And how long did you follow him for?
So he crossed Michigan Avenue southbound towards Bingham Street. Traffic was actively passing, causing a hazard. I gave chase after him. He got to there's a building at the corner there. I believe the address is 1026 East Michigan Avenue.
I'm going to stop you really quick. When you gave chase, were you on foot or did you give chase in your vehicle?
I was on foot.
Go ahead.
So he got to that building at 1026 East Michigan Avenue. When he got there, I was behind him. He made a westbound turn. Now, when he did that, there's a fence line. At the fence line, there's no other exit, but that fence leads over to the right, a parking lot located at 1004 East Michigan Avenue. I observed him jump over a fence, and then after he jumped the fence, his hands were no longer pinned to his waistband. He was actively running.
So you saw him come to the fence and then jump over the fence.
I heard the fence rattling and that he was actively running away on the other side of the fence.
And then you were able to see a change in his running posture once he was over the fence.
Correct.
Did you continue and go over the fence yourself?
I did not.
How did you proceed?
I know the area and that there's an alternate route that leads me to an alley to South Pennsylvania Avenue. And I took that route over to South Pennsylvania Avenue and requested more units to arrive on the scene to assist with everything.
So you had lost contact with him at that point?
Yeah, after he hopped the fence and continued westbound towards Rite Aid, I lost the visual.
Did you ever regain that visual?
So no,
And did you proceed into the Rite Aid?
I did.
Did you ask anybody if they had seen him?
I did.
And what happened? What happened when you asked anybody if they had seen him?
So his coat was located at the front entrance of Rite Aid, and when I made contact with an employee, they advised that they saw a subject run inside all the way to the back storage facility, and that I went to the back storage facility that they mentioned, and another employee informed me that he believed someone was upstairs in a little loft area only accessible by a ladder.
And did you go back there?
I did.
Was there a ladder back there?
There was.
And did you locate the subject back there?
I did.
And at that time, did you detain him?
I did.
Did he ever identify himself to you?
He identified himself as a 15-year-old and then provided a name to a different officer.
Is the person that you saw in that vehicle and the person that you gave chase to, are they in the courtroom today?
Yes,
Could you point to them and describe something they're wearing?
they're wearing the blue jumpsuit.
Let the record reflect that the witnesses identified the defendant.
No objection, Your Honor.
So noted.
And so once you had detained him, what did you do next?
He was placed under arrest for resisting or obstructing. I then went back to the vehicle that was still at Sparrow for evidentiary purposes. Eventually, I gave custody of the vehicle to a different officer and went up to Lansing Police Lockup, where he was transported by a different officer.
Did you ever go back to that fence?
I did.
And
Yes.
what did you see at the fence?
Yeah, at the fence, I located a silver handgun, right where the area where I observed and heard jump the fence.
Did you see him drop the gun?
I did not.
But the gun was located at the fence.
Young
Yes.
man, you okay? Do you need a pen and paper?
Yeah.
But the gun, you said the gun was located at the fence that the spot where you had seen him jump?
Yes.
Thank you. Your Honor, may I approach?
You may.
Just take a brief second. There. All right, there we go. Do you recognize that video?
Yes.
Was your body cam on at the time of this?
Yes.
Was that video from your body cam?
Yes.
Is it a true and accurate representation of your body cam and what you saw on that day?
Yes.
Your Honor, at this time, I would like to admit people's proposed one into evidence.
Any objection?
Objection at this time.
Without objection.
Your Honor, this time I would request to publish this to the court.
You may.
Moving ahead to 30 seconds to where the volume starts.
You shot? Frank 58, I got it. Here up front. Plate's gonna be Edward King, Nora 0160. Edward King, Nora 0160.
You worrying about a license plate instead of helping us get the shot victim in the hospital, bro? He only helped them. It's like 5-4, bro. Can you go? I need to know. All right. Never mind. I'm doing it. I'll do it.
I got you. You sure? All right, I'll stay with the vehicle. Can you open the door? Open the door, please. Hey, Rod, could you come back out here for a second? I got one more occupant in the vehicle. You need to come out of the vehicle.
I can.
Why not?
Because I'm waiting for my mama, 13 years old.
That's fine. Get out of the vehicle. Get out of the vehicle. You're not free to go. Run into the vehicle. Listen, please stop. He's going into the Rite Aid parking lot. He's a black male, 13 years old. 13, blue jeans with a black coat on.
Black male, 13.
Yeah, I'm south of the Rite Aid. Search. He hopped the fence somewhere over here. I don't know. Yeah. He ran inside there. Well, I'll check. Make sure he doesn't run out back. there a kid running here? Back here? You hear that? Yep. Rank 38. He's inside right 8 here somewhere. That's what store employees are saying. Wait, did he run back here? Huh?
Up that ladder is the only place I haven't been back here.
Okay. Hey, Rudd. Back here, there's a ladder. Only place he hasn't checked back here.
Hey, both bathrooms are locked.
Both bathrooms are locked?
Yeah. Men and women are both locked.
All the time, or like, is that normal?
They're locked all the time.
They're locked all the time. That's normal.
Here, here's somebody up there.
Do you mind just getting on here? Lansing Police, bud. Come on out. We don't have to make this a big deal. I think I hear someone up here. Lansing Police. Let's not make this into something. You can come on out. No one here wants to get you in any trouble, okay? Come on out. Hands up, please. Come on out. Come down the ladder.
Please don't hurt me.
No, you're not going to get hurt. Come on down.
You promise.
I promise.
'Cause my mom is
I know.
in the hospital.
I'm getting them out right now.
I'm a little boy, man.
All right.
Trying to hurt me.
No, I'm not. Interlace your fingers.
Okay.
Just like
Yes,
you're praying.
Because my mom, I'm a kid. My mom is in the car, is in the hospital. I shouldn't have to.
Make no sense.
She told me not to fucking talk to y'all.
So you wrong?
Yes, y'all can
Don't
go
make no
talk to her.
sense. Don't make no sense, man.
Y'all can go talk to my mom right now. I'm not trying to run, bro. Only
We don't
ran
know that.
because
You
my
ran
mom.
already?
It's because my mom.
Don't make no sense, dude.
Man, I
shouldn't
told
even-
you it
y'all-
wasn't a big
You're trying
deal.
to pull me out of my car for no reason. I don't have shit, bro. The fuck? I have my phone and my fucking cash. I don't have shit.
You ran from us. How we the ones that trusted you?
Here, check where my nuts at too, so you know. The fuck, I don't got a log, bro. I shouldn't even have to.
Nope, that's it.
Yeah, you
He's,
should have ran, bro. We were just talking to you, not figure out what happened. Your mom.
Record reflect that I'm pausing at 7 minutes and 40 seconds and moving ahead to 13 minutes.
I know you short time. I can take care of it if you want. You sure? Yeah, bro. I'm not trying to hold you over too much. I'm here till 1.
All right. I mean, I'm still. Yeah, I appreciate that. So,
Because right now,
I mean,
I think you clear a paper, right?
Yeah, so he jumped the corner, right? He stayed right in the corner, and
Yeah, because that's where I saw him run this way. I heard the fence going and then saw him right here running.
yeah,
So,
because we were tracking him on the sidewalk on the other side,
yeah.
in case he decided to come back on the other side.
so he came this way.
So
He came,
down
no,
the road.
he went down
Oh,
the
and
other
he
side.
jumped.
He jumped this fence. That's how I ended up over there. Because I wasn't,
okay.
I wasn't trying to hop this.
No.
I was going to go through the church parking lot and come off.
Yeah, that's smart.
But, I'm getting a picture of this up close.
Let the record reflect that I'm 1403. And officer, is that where you found the gun?
Yes.
Is that where you saw him jump the fence?
I'm gonna object, Your Honor, that's misstating the officer's testimony. He said, I don't think he ever said found the gun yet. It looked like he didn't find the gun. There were other officers in that area.
You previously stated a gun was located at the spot where the defendant jumped the fence.
said he jumped the fence, but I don't think he ever said he found the gun.
Well, he did, because I wrote it down verbatim in my notes. So the objection's overruled.
No further questions at this time, Your Honor.
Any cross exam?
So, officer, you were initially dispatched to Sparrow Hospital based on this call.
Yes,
And when the car came in, you witnessed the individuals get out of the car, and that's probably based also on your body cam, is that correct? How many officers were at the hospital that day? You know, I saw some other officers walking around.
I believe 3 were on scene.
Do you know what their names were?
Officer Corey Crenshaw and Officer DJ Rudd
Okay,
and myself.
and yourself, so that would be the 3. Now, indicating from the video that we just watched, body cam and your testimony, you asked my client to come out of the car, is that correct?
I did.
At that point, was he a suspect of any kind?
He was a potential material witness to the potential murder investigation.
Now, I note from the video and from your testimony, it looked like at some point you lost sight of him, is that correct?
Yes,
And that would be when you turned the building to the back of that building, which is located on Michigan Avenue.
correct.
And from your own testimony, I think you said you did not see him jump the fence, is that correct?
Correct. I heard it. I saw him on the other side of the fence.
And you went all the way around to the front of the building. It's like you kind of went around by the church, and came out of Pennsylvania, and then came to the front of the building. Is that correct?
That's correct.
So you saw him on the other side of the fence. But you were not exactly sure what location he jumped the fence at. You're making an assumption that he jumped at that point. Is that correct?
In the general location of that small parking lot. Yes.
You then went in that's a right aid, is that correct?
Correct.
And later on, you located my client in the right aid, is that correct?
Correct.
Now, earlier, when you were testifying, I heard you indicate that you went back over to Sparrow at some point, is that correct?
Yes.
Did you have any interaction with the gun before you went back over to Sparrow? I was a little confused because initially it sounded like you went back to Sparrow and then you started talking about the gun.
Yeah, I misspoke there, and I went to the gun first and then walked over to my car at Sparrow to secure the gun as evidence.
And this gun was found near that fence, is that correct?
Yes.
You did not locate that gun though, correct?
I was informed by Sparrow security officers that that gun was there, and I located it on the ground.
So you were informed that Sparrow security had found the gun.
Yes.
None of the Lansing officers found that gun, is that correct?
Another Lansing officer informed me that Sparrow security was over by the gun. I don't know if Lansing police found the gun or if Sparrow security found the gun, but a gun was located.
Now, you issued a report in this instance, is that correct?
Yes.
And in your report, would it be a safe, if your report would indicate that Sparrow had found that gun, would that be probably a true statement?
I can only testify to what I did and what I saw. I was informed by other officers that that gun was right.
So if you indicated in your report that Sparrow had found that gun, Sparrow security officers, you weren't sure when you wrote that report then whether it was Lansing officer or Sparrow security found the gun?
I'm sure that I was informed by police authority and Lansing police that a gun was located right there, and I saw it with my own eyes.
But that begs the question I just asked you. So when you wrote in your report that Sparrow Security had found the gun, was that a true statement, or were you just, okay, maybe you thought they found it, or that you weren't sure?
Am I able to review my report to see the spot that you're referring to?
No problem. You may.
So I have here what is been indicated to be your report. This is page 3 of 5. Indicates discovery of the firearm. You can read that to yourself. Does that adequately refresh your recollection of what's in your report and what happened that day? Yes. So are you indicating in your report that Sparrow actually found that gun?
Yes.
So it was not Lansing Police that found it, it was Sparrow.
Lansing police took possession of the gun and they never touched it.
But they didn't find it on the ground, correct? That was Sparrow.
You say they never touched you. What does that mean?
The Sparrow Police Authority.
Okay.
But you weren't present when Sparrow found that weapon, is that correct?
No.
So from your own observations or your own knowledge, you're not sure whether Sparrow did touch that gun.
I was informed by Sparrow Police Authority that they did not touch that prior to me.
But you weren't there, correct?
Correct.
So you don't know if they ever touched it, is that correct?
Correct.
Did you take fingerprints off that gun?
I submitted it to evidence for to be printed.
Okay. And do you know if DNA was ever taken off that gun?
I do not know if DNA was taken off the gun.
Now, how long have you been an officer with the Lansing Police Department?
4 years, sir.
Have you been on road patrol that whole time?
In a road patrol capacity, yes.
And that area of Pennsylvania and Michigan Avenue, in your opinion, would you characterize that as an area that does see some crime committed?
Yes.
Now, you indicated my client was touching your hand. And what was the significance of that to you?
From my training and experience, I know that unholstered firearms tend to be secured by holding in the waistband as they're running, so it's not falling, so it doesn't fall out.
So you said training and experience. What training have you had in this area?
I've had the dispatch calls for service, multiple firearm arrests, on-duty trainings provided by the Lansing Police Department.
And what? Explain that training a little bit to me in terms of touching their waistband.
I know that when people carry firearms, they're typically on their waistband.
Now, is that from your opinion, or is that a training that you've had somewhere?
That's training from the police academy to real life experience.
Is there any materials that cite to training manuals or anything like that that indicate that's indication of someone carrying a gun?
Did ask the Mid-Michigan Police Academy where I attended to provide documentation about training about firearms being concealed in waistbands.
Have you ever had any training with any other organizations besides the police academy for that type of situation?
Outside training provided by the Lansing Police Department.
Do you have any special term that you use for that when someone is holding their waistband? All right, so you never yourself witnessed my client with a gun, is that correct?
Correct.
In your opinion, as you have had dealings with defendants in your capacity as an officer, they do carry phones a lot of times, is that correct?
Correct.
And just from your opinion, you made an observation that holding a waistband is to prevent a firearm falling out of that waistband, correct?
Correct.
If you had a phone in your waistband, you might do the same thing, correct?
Not typically.
At any point subsequent to this, did you have any contact with my client's mother?
Just as she got out of the vehicle.
Just as they went into Sparrow?
Yeah, that day, yeah.
So you never had contact with her after that?
Remember?
So it would be untrue that you at some point told my client's mother you saw him throw the gun down?
I don't remember.
I'm just trying to be clear. The question was any time afterwards he made contact with?
Contact that day with my client's mother. Your answer is you don't recall whether you said that or not.
That's correct.
But if you had said that, that would be an inaccurate statement. Is that correct?
Can you rephrase the question? I'm a little confused.
I think my question was, on that day, at some point later, you had contact with my client's mother. You said you didn't. And then I asked you if you had ever told my client's mother that you saw him throw the gun on the ground. You said you don't recall.
Correct. I do not recall.
Okay. Now, is that I don't recall that I said that to her, or I don't recall whether I had contact with her?
Well,
now, as an officer, you go through extensive training at the academy and training also just on how you operate as a police officer on a daily basis. Is that correct?
Right.
And remembering things that happen when a crime is taking place is important. Is that correct?
correct.
And that's why you and the officers, other officers, police departments write police reports to kind of memorialize what happened that day. Is that correct?
To document an incident that occurred, yes.
Okay. So if you had had contact with my client's mother who had gone into the hospital with the shooting victim, it might have been important that in your police report you later on had contact. Is that correct?
If I had contact, let me stop and I guess I'm a little confused by the question. Are you saying, is it important to document that I had contact with the mom that went inside Sparrow?
Correct. Your job as an officer is to investigate crimes. Part of that investigation is you memorialize those in police reports, correct? Document them in police reports. So we have a shooting victim who went into the hospital, was taken in by my client's mother. You indicated earlier that my client was maybe a material witness to that shooting. And certainly if his mother was with the person who was shot and took her into the hospital, she would be a material witness. Is that correct?
Correct.
So if you had had contact with her, it would be important to memorialize that or document that in a police report. Is that correct?
Correct.
But at this point, your answer is you don't remember whether you had contact with her.
outside after your original question was, did I have contact with her after I had placed him in custody?
Correct.
Which I don't recall. I don't.
Okay, you
remember
don't
doing
recall.
that.
So, and then you don't recall whether you said to her, I saw him toss the gun on the ground. Did you take the phone off my client that day when he was placed under arrest?
Different officer did.
So the bottom line is, you don't know, you never saw my client with a gun that day, correct?
Correct.
That's based on what maybe someone else told you, or that a gun was found by a fence line where he jumped, correct?
It's from my observations and training and experience in the location of and discovery of the firearm.
Okay, but you never saw him with that firearm.
Correct.
No further question. Your Honor.
Any redirect?
Briefly, Your Honor. And so you base that decision or the thinking, thought process that there was a gun based off of the totality of the circumstances, is that correct?
Correct.
And what were those circumstances? Just if you could briefly like bullet point them.
Yeah. Ongoing potential homicide case with a known gunshot wound victim. Finding the subject in the transport vehicle of the gunshot wound victim. Okay. Moving around in the vehicle, disobeying commands, running from the police, holding the waistband as they're running, hopping a fence, and then where the firearm is located, now having free movement with both hands as they're running.
Thank you, Officer. No further questions.
Were you ever able to determine how old this defendant was?
After he was transported to lockup, he identified himself properly.
Oh,
And that he was an adult.
okay, so he wasn't 13?
No.
Oh. Any other questions based on that?
Nothing from the people. Thank you.
Any thoughts based on that? Thank you, officer. You may be excused. Call your next witness.
The people call Robert Forbes.
You may. Officer Forbes, I think that you may no longer be needed. Thank you.
That's
You
correct.
can hang tight in case that changes.
People rest this time, Your Honor.
Okay, you need defense.
You have no
witnesses? See the argument.
Thank you, Your Honor. Officer Uvera testified today that there was an individual located in a vehicle where somebody had come in with a gunshot wound. He asked that individual to exit the vehicle multiple times. He was in full Lansing police uniform. The individual refused to exit the vehicle, claiming that they were only 13. He then attempted to walk around the vehicle to unlock it to get him to exit. As soon as he did that, the defendant got out and took off running at a fast pace. As we saw in the video, Your Honor, he had his left hand pinned to his waistband as if holding something in during this process of running. Officer Uvera followed him and heard the fence rattle, and then came around and said he saw him the defendant on the other side of the fence, running with both hands free, no longer holding anything, no longer pinning anything to his side. He eventually did make contact with the defendant back in that Rite Aid, where the individual had told him again that this time that he was only 15. Your Honor. And then he heard from somebody, he had heard from Sparrow Security that there was the firearm located by the fence. And Officer Uberoth went back around to where he had heard him jump the fence and saw him running after and found a firearm located, at that fence. Only 12 minutes, less than 12 minutes has elapsed for the time the defendant got out of that vehicle and the time the gun was located on the underside of that fence, Your Honor. Officer Uberoth, very, very, very detailed on the totality of the circumstances that he believed that the individual had a gun, Your Honor, and that was the holding of the waistband. The gunshot had just happened, and there was a gunshot victim, along with the running with two hands afterwards and freeing it up, and the finding of the firearm, Your Honor. At this time, we would ask it to be bound over on all counts of the complaint, Your Honor.
Thank you, Your Honor. What I would indicate here today is we watched the video in court today. It seemed to be a very chaotic scene that was going on. Clearly, the officer was chasing someone who was later identified as my client. It'd be hard to argue against that. As I watched that video, I had a hard time seeing anything in that video as in terms of my client holding his waistband. It was very chaotic. I know the officer testified and saw that. Officer lost contact with my client by his own admission at some point. He did see my client on the other side of the fence, and heard the fence, I guess, rattling is what he said, went all the way around by the church and then found my client inside the Rite Aid. I don't know that the officer ever testified that he found the firearm, which is what I heard Brother Counsel just say. Certainly a firearm was located near the fence. I'm not even sure who located that firearm. 12 minutes. I'm not sure who touched that firearm. If the firearm was ever touched, if Sparrow found it. Indication was that Sparrow might have found the firearm. They're not here to testify today that they found that firearm there. It's a high crime area. 12 minutes. Gun could have been there 12 minutes. It could have been there 2 days for all we know at this point. I'm going to ask you not to bind this case over on the weapons charges, both felony firearm and CCW. I don't think there's any evidence to directly tie my client to that weapon. Your Honor could say, well, there's circumstantial evidence and there's a totality of the circumstances, but on the bottom line is no one ever saw my client with a weapon that day. The weapon was covered in that vicinity. The weapon could have been there a long time. I understand if your Honor is going to bind my client over on the other charge, resisting, obstructing, and fleeing. Clearly, he ran from the officers that day. But at this point, I'm going to ask that you not bind it over on the weapons charge. There's no direct evidence at all to tie my client to that gun.
Okay.
And the fact that
Direct
he's holding
evidence
his
isn't
waistband.
required, though, is it?
Pardon me?
The direct evidence is not required. Circumstantial evidence is sufficient. Are you disputing that?
I understand that, but
I don't want you to make your client believe that there needs to be direct evidence. Circumstantial evidence is sufficient.
That's correct. I'm not going to argue against that, Your Honor. In fact, we had a discussion about circumstantial evidence. But I don't even know that they have sufficient circumstantial evidence here. They found a gun near a fence. My client jumped the fence. I don't know. Your Honor will do what you.
There's a question. Sounds like it's a question of fact then, which is for who? Trier of fact and not for me, for a jury, or if you decide to have a bench trial. Did you have any re-argument?
No, thank you. Not at this time, Your Honor.
Okay. Can you replay the beginning of that video for me, please?
Yes, Your Honor. Leave me to start at 30 seconds when the volume starts, Your Honor.
No, this is fine. Let me turn it down too, because I think we were disrupting Judge Flores. Not that I have too much control over the volume issue. It's a fake wall here.
Am I muted?
Yeah, I don't need the volume.
Okay.
streaky of black in me. Okay, that's all I usually see. Thank you. Okay.
Matter if I may.
You may.
Additional legal argument. So just presented to me by a colleague. By the officer's testimony, he indicated my client was a material witness in this client, which may have been a potential witness. He never indicated my client was a suspect. In fact, I asked him if the client was ever a suspect. He said, no, he's a material witness.
In the potential shooting or the homicide one, is that what you're talking about?
Correct.
Okay.
He initially had contact with him. Therefore, the interaction between the officer and the client was not based on any reasonable suspicion, simply because he was a material witness, not a suspect. It was simply a normal encounter. It was no different than the officer talking to any other person. Therefore, my client didn't have to stop and answer any questions of that officer. And I think that's under Dunway versus New York, that's 442 US 200, Terry versus Ohio, 392 US 1. Person approached under these circumstances is free to leave. It's not a seizure.
This ain't the church. We don't need you to say amen, okay?
Yes,
Let
Your
him
Honor.
formulate your argument for you. Thank you.
Yes, Your Honor.
Any argument based on that?
1 second.
You take your time.
Yes, Your Honor. At this point, Your Honor, he did say he could have been a material witness, but at this point, he could have also been a suspect based on the circumstances, Your Honor. The officer showed that there did come a gunshot victim in, and the defendant was in the car, Your Honor. So at that point, he could have been a material witness. He could have been a suspect. The officer didn't know. He just wanted the question to ascertain whether he was a suspect or a material witness, which is why he wanted to talk to him and get him out of the car in order to talk to him about that, Your Honor.
Thank you. Today's the date and time set for preliminary examination. For your information, Mr. Eskin, at the time of preliminary examination, the burden is squarely upon the prosecution. They need to provide sufficient evidence that there's probable cause that a crime was committed and probable cause to charge you with the crime. Probable cause is a burden that is not to be compared to the burden that you would face if this matter goes to trial. At trial, the prosecution has to prove each element beyond a reasonable doubt. That's not what's going on here. It's a very low burden. It's more than mere suspicion that a crime was committed that they need to determine at this point, and it can be based on circumstantial evidence. I'm the sole determiner at the time of preliminary examination as to credibility of the witnesses. Today we have heard testimony from one witness, that being Officer Uberoff, I believe is how it's pronounced. Indicated that if the time in question, that being January 14, 2023, at the area of 1215 East Michigan Avenue, City of Lansing, Ingham County, State of Michigan, making venue in this court appropriate. He was dispatched to Sparrow in response to a gunshot wound victim. He also did indicate that there was an investigation as to a homicide, and that the parties, the majority of the parties have exited the vehicle, that there was one individual or subject in the rear of the vehicle, and that he asked or tried to inquire or speak to the person asking to get out of the vehicle, and that he was doing that as part of his investigation. The question is presented by the defense counsel is that the investigation was that he was a subject to a witness or a possible witness. Prosecution makes a viable argument that he could have been a possible witness, but also he could have been a potential suspect. Officers at this time don't really know. They do have a vehicle that arrives to the hospital, and there's a victim with a gunshot being or a wound, or some sort of wound, which presumed to be a gunshot wound, is being transported into the hospital. Officers asked the gentleman or the subject in the back seat what their name was or their age, upon which that individual said that they were 13 years of age. There was a engagement back and forth between the officer and the person identified as the defendant in this matter, who was the subject in the rear passenger side of the vehicle, before the subject vacates the vehicle on foot, southbound, and there is a foot pursuit between that subject and the officer. I asked the video to be replayed because the officer testified that while he was chasing the defendant, that the defendant was holding, using his left hand to hold his waistband, and that through his training and experience that's commonly associated with an individual who's trying to hold or a firearm. Looking at the video, I can't see that either, but that's because we're looking at a body cam, which the person who's wearing the body cam is running as well. But he testified as to what he saw, and that can only be identified by a more still a clip of what took place. But as he's running behind someone who's running, I can't necessarily see what's going on in the person's hand. I do see the person that's clearly identified as the defendant here running from the officer, after officer giving loud verbal commands that it's the police, Lansing police, and that he is to stop. And I do see that the defendant ran and jumped a fence in the area in which the officer testified that either he found the firearm or the Sparrow security located, and the Lansing Police Department took the firearm into possession. Whether or not the officer himself located the firearm is not really germane for this purpose. I don't believe that the officer intentionally misrepresented those facts for the court. He may or may not have been confused or unclear or just mistaken as to who originally located a firearm. What we do see based on the body cam video, that a firearm was located in the vicinity of the area in which the defendant was seen jumping the fence. The defendant was found hiding inside of a Rite Aid on a ladder in a break room or back storage room of some sort, and taken into custody. In order to be charged or convicted, that is, of the count 1, weapon carrying concealed, at the time of trial, that people would need to prove beyond a reasonable doubt the defendant knowingly carried a pistol. It does not matter why the defendant was carrying the pistol, but to be guilty of the crime, the defendant must have known that he was carrying a pistol. Second, that the pistol was concealed on or about the person of the defendant. Completely invisibility is not required, and the pistol is concealed if not easily. The pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. What we have here is circumstantial evidence that the defendant was carrying a concealed weapon. He was evasive of the officer, took off running. Officers chased him, and in the area upon which the defendant is seen on the video jumping a fence, there is a firearm later located in that vicinity. That's sufficient probable cause to charge the defendant with count 1, weapons carrying concealed. That will be bound over to the circuit court. Count 2, police officer assisting, resisting, obstructing, based on the testimony and the evidence shown by the video of officer giving verbal commands for the defendant to exit the vehicle, the defendant giving false information, then taking off to a run, causing the officer to pursue him. The court is satisfied that there's sufficient probable cause that the defendant did obstruct the officer or oppose the officer as he was knew the officer or had reason to know was performing his duties. And so that will be bound over as well as count 1 to the circuit court. Count 3 is weapons, felony, firearm, the as charged indicating that the defendant had a firearm in his possession while he committed or attempted to commit the felony, to it being resisting, obstructing. The court is satisfied that there's sufficient probable cause as to count 3. All counts as charged will be bound over to the circuit court for a bind over date of February 15th. That is not a date that you need to appear in court. That's a date upon which the circuit court will receive the file from this court. Your next court date in circuit court will be a pre-trial. You and your attorney will be made aware of that date. Okay, sir?
Here's your own.
The bond is set at $20,000 cash surety. That will continue. Any additional matters for the record?
Nothing for the people, guys. Thank you.
I'm just gonna make a motion on production of bond.
Okay, you can proceed.
My client has a young child at home. He's got one on the way. Young man, he was on probation with Judge Kennedy. He's been released from that probation. With insurance sanctions. That file was closed out. I think that played into why he was on such a high bond. He was on Wisconsin. That file, he's already adjudicated that with Judge Kennedy. He's been released on that charge. This is the only thing he has pending right now. Also, I request, thinks he's a flight risk of tether. I know that he can present proof that he is indigent at this time to have that paid for. So I would just request reduction by 10% with the PR with the tether.
Is he on federal probation?
Pardon me?
I have a note here that he was on federal probation.
He's not on federal.
Okay. That's good.
Your Honor, I'd ask that bond remain the same. He was on probation at the time this matter happened. He was a little probation. He was absconded from a matter. While he's clearly a flight risk, Your Honor. He was absconding during this time when he was on probation. So I'd ask that Your Honor keep the bond in place.
Based on the fact that he wasn't absconding from probation at the time of the alleged incident, it's a clear indication he doesn't do too well with court orders. The motion to amend bond is denied. Bond will continue as set. Any additional matters for the record?
No, that we have to. Thank you, Your Honor.
Thank you, Your Honor.
Are you representing Ms. Standish as well? She was here. Oh, she might have just taken her baby out. Are we having
One more client, she must have gone outside.
Ms. Standish or someone else?
We're just gonna find out.
Yeah, that's what I was looking for. I know she was here, but I think she just stepped out with a baby. Ms. Standish. So she may be in the hallway. Okay, we're on the record in the matter of the people of the state of Michigan versus Jessica Joe Standish. File number is 20-03071. Council appearance.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
Thank you, Honor. Dale Culture appearing on behalf of Ms. Standish, who's standing immediately to my right.
Okay, Ms. Standish, today's the date and time that is set for a preliminary examination. My understanding though is that there's a waiver to the circuit court, correct?
That's correct, Your Honor.
Is there an offer?
There was no offer at this time, Your Honor. I believe the plan was to get her screened for drug court.
That is correct. She has a number of cases. I'm working towards a global resolution.
Okay, Ms. Standish, how are you?
I am okay.
Okay, well, hopefully you get better. Today was the date, or is the date set for preliminary examination? You have the right to have a preliminary examination. You have the right to have the prosecution put on sufficient evidence to establish that there's probable cause that a crime was committed and probable cause to charge you with the crime. You understand that? You want to waive your exam today? Is that your signature on here?
Yes.
Okay. Anybody threatening you to get you to waive your examination? Has there been any promises made to you in exchange for waiving, and you're waiving your exam freely and voluntarily?
Yes, ma'am.
Okay, you understand that this waiver is unconditional, so that means that once you waive this matter will be bound over to the circuit court for further prosecution. No hearing will be held here in the district court to establish probable cause. You understand that?
Yes, ma'am.
Understand that you're being charged with 1 count of retail fraud, first-degree felony, maximum penalty 5 years and or $10,000 or 3 times the value.
Yes, ma'am.
Okay. This matter will be bound over to the circuit court. Your bind over date is going to be February 15th. You do not need to appear in court on February 15th. That's the date they get the file from this court, okay?
Okay.
Your next court date in circuit court will be a pretrial. You and your attorney will be made aware of that date. Can you confirm your address for me?
801 East St. Joseph Street, Anson, Michigan, 48912.
Okay, your phone number ends in 2083.
Yes, ma'am.
Okay, any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further. Your Honor.
Bond will continue as set at 2,000 personal recognizance. Thank you.
Thank you for your time, Your Honor.
No problem. Who's first, Hunt?
Yes.
We're on the record in the matter of the people of the state of Michigan versus Jerome Edward Lee Hunt. File numbers 22-01597, 20-01232. Council appearance.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Hunt, who is present and staying to my right at this time.
Thank you. How are you, Mr. Hunt?
I'm glad. Good morning, Your Honor.
Good morning. Today's the date and time that's set for both a preliminary examination and then a probation violation hearing. I have a plea sheet here. It says the people are offering on the felony matter for you to plead to an added count of larceny less than 200 under MCL 750.3565. It's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines or 3 times the amount. And that you were going to pay restitution in the amount of $111. They'll dismiss count 1 upon successful entry of a plea to count 2, and there's a Killebrew agreement of no upfront jail. Is that a complete and accurate statement?
That's correct, Your Honor.
It is, Your Honor, yes.
You want to accept that offer? You sure?
Yes,
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. Okay, I have an advice of rights of plea information sheet. Is that your signature?
Yes,
You read this document?
yes, ma'am.
You understand the rights here?
Yes.
You have any questions about these rights? Okay, you understand that you have the right to proceed to a trial in this matter? You understand that the purpose of the trial is for you to execute your right to have the prosecution prove each element of the charge being brought against you, and they have to prove each element beyond a reasonable doubt. You understand that? You want to give up that right?
Yes.
Okay, sure?
Yes.
Okay, so that means you're gonna give up your right to see, hear, or question any of the witnesses that the prosecution intends to call. You're gonna give up your right to call your own witnesses to trial or present evidence that you believe would further a defense to this charge. You're gonna give up your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that? And you wanna give up that presumption of innocence?
Yes, sir.
You're gonna give your right to remain silent, not have silence be used against you. You understand that?
Yes, sir.
You're gonna give your right to claim later that you pled guilty because you were under duress or that someone promised you something. So are any promises being made to get you to waive your rights?
No, ma'am.
Any threats being made to you to get you to waive your rights?
No, ma'am.
Are you currently, well, you're on probation. Are you currently on bond or any other matter?
No,
Nothing
ma'am.
else pending?
No, ma'am.
Okay. You understand that a guilty plea could result in a violation of your bond conditions, or I'm sorry, your probation conditions?
Yes, ma'am.
Okay. You understand that a guilty plea can result in the conviction that you may need to report to either a future employer or to your current employer.
Yes, sir.
You also understand that a guilty plea can result in a conviction that may have impact on any immigration or travel status that you may be seeking.
Yes, ma'am.
As to the added count 2 of larceny less than 200, how do you plead? Are you pleading guilty because you believe you're guilty?
I believe that I'm guilty.
Yes.
Yes.
Okay, factual basis.
You should speak up. Oh, appreciate it. I'm
Factual,
sorry.
factual basis.
Thank you very much, Your Honor. Okay, Mr. Hunt, I'm going to ask you a few questions, okay? On or about March 13th of 2022, at or near 1014 South Pennsylvania Avenue, City of Lansing, County of Hingham, were you walking around on the streets that day in that location on that day?
Yes, sir.
And on that day, did you happen upon a car or go up to a car that day?
Yes, sir.
And did you take something out of that car?
Yes, sir.
What did you take?
It was,
Like a credit card? Is that what you're saying?
yes, sir.
Okay. And with, did you have permission to take that credit card? Do you know a Kristen Benoni Wright?
No.
For purposes of this plea, was the value that of the card that you took, was that under $200?
Yes, sir.
And you would agree that there is a restitution amount that is being requested, and we do agree to a $111 restitution, is that correct?
Yes.
when you took that property, did you take it to a gas station and use it to purchase goods?
Yes, sir.
And was it your intention at that time to permanently deprive the individual of that car? In other words, keep it for yourself?
Yes, sir.
Thank you, Your Honor. If there's anything further.
Anything from the prosecution?
Not a thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. The victim here.
No, Your Honor.
Okay. Okay, well, then we have to set up a sentencing. I don't really see why I need to refer him to probation before sentencing, because he's already on probation, aren't you?
Yes, sir.
We have a probation violation hearing today. Should we address that now?
Yes, Your Honor. It's good.
You want to have a hearing or?
No, Your Honor. I did have the opportunity to explain to my client his rights regarding a hearing. It's my understanding after explaining that to me, which is to waive his right and admit to the violation in this matter, Your Honor.
Okay, well, we've already put you under oath, sir, so you understand your right to have a contested hearing on the violation, sir?
Yes, Your Honor.
Violation is that you failed to appear for probation orders. September 27, 2021.
Your Honor, I would also just like to note for the record, as the court has already indicated regarding the plea itself, that could be a basis for a probation violation here. Having conferred with my client, I do believe that there is a valid excuse for him not showing up on that particular day, Your Honor, which we will explain in due course. However, overall, we do realize that there's going to be.
On September 27th, you mean?
Correct, Your Honor.
Okay, and October 6th, 2021. Yeah, valid excuse for both?
I believe so, Your Honor. But we recognize that there is a probation violation, which we will also come out during the explanation. And as the court has already noted, a plea that he just entered would be a violation of probation as well. So it's based on my advice that he's going forward with this plea and he is accepting full responsibility, knowing that he did ultimately abscond, even though that's not written in the formal violation.
Okay, that's correct, sir.
Yes.
Do you have any questions about your rights as it relates to probation in this violation hearing?
No, ma'am.
And you want to plead guilty to the violation?
Yes.
Is Mr. Milks threatening you?
No, ma'am.
Plead twice.
No, ma'am.
Okay. All right. As to the violation that you failed to appear, the probation orders appointments back on September 27th and October 6th, 2021. How do you plead? Mr. Milks?
Thank you, Your Honor. Purposes of factual basis. Sir, on those two dates that the court just indicated, where were you at that for both of those dates?
I was incarcerated in Calhoun County, Straddle Creek, and I've done a year there, and then I got released. And
So I'm gonna stop you right there real quick, okay? In the case that you were on probation for this court, you were in jail when you pled guilty, is that right?
Yeah.
And once you pled guilty, were you released from Ingham County Jail?
Yes.
Where did you go immediately after being released from Ingham County Jail?
Well, they transferred me to Calhoun County Jail.
All right, now, sir, there did come a point though, obviously before March 14th, 2022, which was the date of the offense that you just pled to, that you were released from Calhoun County, is that correct?
Yes.
And you realize now that you were required, as told at the time of your sentencing on this case, that you were required to go to probation department, is that correct? Yes, sir. Did you ever call or end up going to the probation department?
No, sir. I got released from there, and then I went to the other program, which is
We'll get into that in a little bit. But you would agree you did not go to the actual probation department, correct?
no, sir.
All right. Yeah, would the court like me to keep going or just kind of turn this into an allocution?
You can go into allocution.
Okay.
I'll
Thank-
accept your plea. If Frank, please be made freely, voluntarily, and intelligently.
Thank you very much, Your Honor. Your Honor, to expound a little bit here, we did have a sort of impromptu meeting with the court out of chambers, where the court, and I understand where the court's coming from, had some concerns regarding my client absconding since 2020, Your Honor. In this situation, though, in 2020, when he was originally sentenced in this case, or at least pled guilty on this case and required to meet with his probation officer after sentencing, he was already in jail for 20 days. He was then released. Calhoun County picked him up. He had to do a year in Calhoun County, which brings us roughly to 2021. He was released in 2021. And this is where obviously absconding begins. However, he enrolled himself in an LRP program, Your Honor, which was a Christian-based program. Because he did have a significant substance use problem. I confirmed this with my client, and that's what he had indicated, that was a struggle that he was going through. He was in that program for 5 months, Your Honor. As I can attest, he relapsed. It happens. It's not something he's proud of. However, what he should be proud, and during the relapse, Your Honor, is when March 14th, 2022 occurred. Following that, though, he did enroll himself in recovery groups, Your Honor, and he found recovery through the church. In particular, the Rema Outreach Center, Your Honor, with Pastor Raul, is where he found a lot of strength, and he found community-based programming, which he has been attending, has continued to attend. And that's an incredible thing he's no longer using. And I believe it's him showing good faith efforts, Your Honor, that probation may be appropriate in the other matter, Your Honor, understanding in this matter, maybe a termination without a jail sanction, which would give him an opportunity to remain on probation in the other case. We know what I'm asking for quite a bit, and we're asking for a lot of trust from the court. However, I do believe that it is warranted in this matter, Your Honor. First thing I think of is whenever someone says that they find Jesus, there always seems to be that they find Jesus in jail. And it's something I always kind of think, well, it seems a little bit like BS.
We can't use Jesus and BS in the same sentence. Okay?
That's fair, Your Honor. That is absolutely fair.
Don't do that.
However, I tested Mr. Hunt, asked him about his faith-based programming and what he meant by that. And I was very and genuinely impressed. It does seem like he is really taking to this. He says, go ahead and test me. I'm going to be clean. And so, Your Honor, I think this is one of those opportunities where perhaps giving him some grace to prove to this court that he is the changed individual that he says he is, may be warranted here, Your Honor. I would ask that the court consider that, or at least maybe set the other matter for sentencing to allow him for further investigation, Your Honor. So unless there's anything further I would leave with my client, I do appreciate it, Your Honor. Thank you.
Thank you. Mr. Hunt.
Yes, ma'am.
Your attorney has indicated on the record, there was a impromptu off the record conversation about this particular case. They coordinated me actually in the hallway, he and the prosecutor. They wanted to know if I would consider, although the recommendation is to revoke or terminate your probation status and impose jail time because you had absconded, if I would consider not doing that. And your attorney, as you can see, he's going to advocate zealously for you. He's a great attorney. But I couldn't do it just because it makes a good argument. I said, I need you to tell me why you want to continue on probation, because you didn't show up the last time. So why waste our time if you're not interested? He did provide additional information now that I wasn't aware of, that you had participated and enrolled in the LRP program. So what dates was that you were in LRP?
If I can recall it, I think it was 2022, like around about August, September.
Of last year?
Yes, ma'am.
Okay, so this was not during the time that you were just getting out of Calhoun County.
Well, I got out of Calhoun County. I don't know the dates right now.
You gotta count, well, we sentenced you on this. I think you originally pled while you were in Calhoun, said you were sentenced. You were supposed to appear, I think, August 20th for sentencing. You didn't appear. And so a bench warrant was issued, but then you appeared later. So I'm assuming you must have been released because you appeared late, like September of 2021. And that's when I sentenced you to 12 months probation. But then we got the probation violations because you never appeared to go over the orders and to start the probation. So you really never started. And you remained in warrant status for a long time.
I remember.
So there was a time period where you got some treatment, you lapsed, and then did you ever go back to jail during that time?
Around, not after I got out of the program.
Okay. Okay, well, I recognize you probably can't keep up with the deadlines. What we know for a fact is that you didn't do the probation. And it sounds like you've tried to make some efforts on your own to address your underlying issues, because all three of these matters, the one that's you're already on probation for was for 2 counts of larceny, same as what you just pled guilty in the underlying issues, clearly some substance abuse issue. And so it sounds like you're trying to or have worked to make resolution on that. I am going to set this these both for sentencing on a date in the future, not March 31st, because February 16th, that's too far. Very good, thank you. We're gonna do February 16th at 8:30 in the morning. That'll give the victim in the new matter an opportunity to appear or make a statement if they would like. And then at which point we can address this matter, the new matter. I'm actually going to continue your probation on the other matter, and it's going to be for 6 months. Continued. You need to go down to probation when you leave here, okay?
Yes, ma'am. Is that located, excuse me, is that located here?
Yep, they're right on the 5th floor. No, sentencing is on the new file.
Oh,
Yeah, the other one, he's not gonna get, he's being sentenced to continued probation. On that one, just gonna start you off with 6 months, and hopefully you've addressed the underlying issues and we don't need to go further than that. Do you have any questions at this time, sir?
No, Your Honor.
We will get you over to probation, and then we'll see you for your sentencing on the other matter on February 16th, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
And nothing from the defense. Thank you very much, Ron.
Thank you. We have Matthew Thomas here.
Oh, yeah, that's right. Oh, thank you. No,
No. Matthew. Did you hear from Matthew at all?
Yep. Very proud of him, talking to me and walking through everything.
Interesting. Okay, well, we'll do a bench warrant.
And, is this under the 48-hour?
No, because he was here before, he kept logging off, continued to pee, and then we set up a bond violation. So we need him to get in here and address this issue. What I will do is, if you hear from him today, I won't sign that, but he's not getting 48 hours.
It's very kind of you, Judge. Thank you.
Okay, there's that. We're running done.
We are not running done at this time, Your Honor.
that'll be a waiver to circuit court.
Okay, so we need Bigelow to bring Dunn up. People of the State of Michigan versus Kent Dunn, file number 23-00028. Council appearance.
Brian Ring on behalf of people practicing under Michigan Rule 8.120.
Morning, Your Honor. Jared Austin, appearing on behalf of Mr. Dunn. He stands present to my right at council table.
How are you, Mr. Dunn?
As well as I can be for my circumstance.
Reasonably stated. Okay, today was the date and time that was set for preliminary examination. How are we proceeding?
Your Honor, at this time, the people will be moving to dismiss count 1 and then add a count 2 motor vehicle unlawful driving away under MCL 750.413, and I believe there's going to be a waiver up to circuit court on that added count, Your Honor.
Added count to unlawful driving
Unlawful
away.
driving away.
Back over again.
750.413.
Okay, and the parties unconditionally waive their exam.
That's correct, Your Honor.
Okay, that's correct.
That is my understanding as well. Yes, Your Honor.
Okay, so the motion to amend the complaint would be granted. And then, Mr. Dunn, you understand that you have the right to have a preliminary examination in the district court?
Yes, Your Honor.
I understand that the purpose of that examination is to require the prosecution to put on evidence to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with that crime.
Yes, Your Honor.
Okay, you want to waive that exam unconditionally today?
Yes, Your Honor.
So you understand that unconditional means you can't change your mind once this matter is bound over. You understand that?
Yes, Your Honor.
Okay. Okay, anybody threatening you or promising you anything to get you to waive your examination?
No, Your Honor.
You're waiving it freely and voluntarily?
Yes, Your Honor.
Is that your signature on here?
Yes, Your Honor, it is.
Okay, your matter will be bound over to the circuit court for a bind over date of February 15th. That's the date that the circuit court gets the file from the district court. Your next court date will be a pre-trial, so you do not need to appear in court on February 15th, okay?
Okay.
You and Mr. Austin will be made aware of the new court date once it's set. Let's see. Okay, your bond was set or reduced, I think at the last hearing, to 5,000 cash surety with the no contact order protecting a Lance Hunter. Any additional matters for the record today?
Nothing about the people. Thank you, Your Honor.
If I may address bond, Your Honor.
You may.
Thank you, Your Honor. The court did grant our motion last week to modify, reduce Mr. Dunn's bond. However, that was still when the carjacking charge was pending, which is a life offense. Given that that charge has been dismissed, Your Honor, and Mr. Dunn is waiving up on a far less serious nonviolent felony, I would ask the court to consider reducing that even further. We did review Mr. Dunn's criminal history last week when I made that motion. He does not have a history of failing to appear in court. He's going to be living locally in Charlotte, I believe, with family, has children, health issues. He is on bond in his current matters, which are nonviolent weapons offenses pending in circuit court. My understanding is that he is in good standing with his pretrial release conditions on that matter. And even though the court did reduce his bond, it's still a matter that he can't afford to post. And given that he's no longer facing a capital offense, I would ask the court to consider reducing it even further to personal recognizance. He was not on bond at the time of this alleged offense, so there is not that prohibition on the court, or as an alternative, if the court does not feel comfortable doing that, I would ask for a 10% bond. Thank you.
Did you want to respond?
You know, at this time, I would just leave it to the discretion.
Bond will be amended to $5,000 personal recognizance. The no contact order will continue, okay?
Thank you, Your Honor.
Do you have any questions about the no contact order, sir?
No, Your Honor, I totally understand that I am not to speak with him if I see him, avoid him, and to do everything in my ability to not have any communication with him.
Or exactly, so that also means like third-party communication, you understand that?
Yes, I do. No Facebook, no somebody else talking to him, anything like that.
Bingo, sounds like you're very clear and you're not interested.
Not at all.
That's what we like to hear. Any additional matters for the record?
Nothing on behalf of people. Thank you,
Nothing
Your Honor.
further on behalf of Mr. Dunn, Your Honor. Thank you very much.
Thank you. Good luck, Mr. Dunn.
Thank you. Appreciate you guys.
Do we gotta pick?